our next session is on global jurisprudence on SEP. This will be a general session which will clarify common aspects relating to SEPs, such as the interplay of R&D efforts, essentiality, declarations, working of SSO licensing aspects, and various other aspects. The session will be chaired by Ms. Gabrielle Mosler from Ericsson. She is the Vice President of Patent Development at Ericsson and a telecommunication engineer. She is also an expert in patents and European litigation and has been working with Ericsson for more than 25 years now. She has a master's degree in electrical, electronic, and communications engineering technology from the RWTH Asian University in Germany. Over to you, Gabriel, for the session, and wish you all the best of luck. Instead of Ms. Pamela Kumar from TSDSI, we now have Mr. Dr. A.K. Mittal, who has joined us. Thank you, sir, for joining us on such a short notice. Ms. Pamela actually has been detected with COVID, and so she could not join us. Mr. J. Kasan, I think he would join, but I think, Gabriel, you can start the session meanwhile. Thank you. Over to you.
Yeah, thank you very much. I just want to ask, because in our outline there is a break plan, so maybe that's why Jay is joining a little later. So we get started anyhow.
Yeah, you get started. Yeah, you can get started, please.
Okay, and we have the 1 hour, or we have a little more?
You have 1 hour.
Perfect. So our plan is to...
I'll raise the hand when I have to, just for your information that the session is coming to a close.
Yeah, okay, perfect. Thank you very much.
5 minutes before that, yeah.
So first of all, thank you very much for having me and moderating this this panel. Let me introduce you a little bit to our panelists and to the theme on the global jurisprudence in SEP and Frand licensing. So with me in the panel, and I start, you heard that Pamela Kumar unfortunately has fallen sick, and I hope that she has a fast recovery and not that bad. So let me start in this case with Mr. Mittal. He is an advisor an associated advisor to TSDSI with a special focus on standardization in wireless and wireline systems, and is very active in the area of 3GPP and ITU. He himself began his career in the Indian telephone industry and later on joined the DOT, the Department of Telecommunications. Let me go to the next speaker then here, which is Mr. Dr. Kevin Scott. He's a senior director at Royal Philips. Kevin is responsible for licensing in Philips for patents to third parties in the technical areas, including telecommunication, UMTS, LTE, 5G, and wireless power, leading a global team of licensing professionals. He has more than 20 years of experience in the licensing of standard essential patents to companies and has extensive experience in multinational litigations of SEP. Next one is Eric Stasik, founder and managing director of Avika AB. Eric Stasik is the founder of Avika AB, as mentioned, a consulting firm located in beautiful Stockholm, Sweden, specialized in licensing standard essential patents and other patents for telecommunication industry. He's an electronic engineer by training, and he has worked with SEP licensing for more than 25 years, also within a telecommunication company. So he's also a well-known author of books in the area. The one we are missing, and I think that might be due to the early hour, is Mr. Dr. J. Kasan, but I hope he's going to join us in 2-3 minutes. Jay Kasan, he's worked on technology, law, and business. He is a professor in Illinois, and he also is also practicing patent attorney for more than 20 years. He himself actually is also an inventor, and he has worked in both the areas in telecommunications and in the law area. So with me, I really have, I would say, if I count the years of experience, it's unimaginably long, and I think that is fascinating to see. But obviously, once you touch the field of licensing in the SEP and standard essential area, this is what you are. But it also shows one thing, and with this, let me give a short introduction. Standard essential licensing is existing for decades, for a long time. This is not a problem or a challenge just lately. It has been very, very successful since 2G, maybe when these were the years when here my distinguished panelists were starting. It was a working theme already in these times and is over 2G, 3G, 4G. It is 5G and it will be 6G. It is working if we let it work. And with this, let me start with my first comment and question to Mr. Kevin Scott. Kevin, you are, as we also know, have a technical background, come from the area, and you're very actively in it. Can you give us a short introduction into ETSI standardization, the working of the SSO? Can you share this with us, please?
Okay, sure, and thank you for the introduction, and happy to do that. So, if we look back, the SSOs came out of the development primarily in Europe in the telecom area in the 80s and 90s, when it became obvious that for the market to move forward, we needed to go away from merely national development of mobile phone technology and move towards something that was more regional at this time, but it involved the cooperation of a lot of companies and both telecom operators and companies that developed mobile phone equipment. So people like Ericsson, Nokia, even Philips at that time, and a number of others. And so the setting up of the standardization involved these companies getting together and to develop telecom standards. That in itself gives some issues. The first is that you have a number of competitors coming together, which is the sort of thing that gets the interest of the competition authorities, because it's somewhere that you have to be careful. So the European Telecom Standards Institute, which is where a lot of this work was developed, needed to set out working procedures to make sure that this wasn't an issue. So one of the things is making sure that the companies were, or the developers of the standard were tasked with coming up with the best technical solution. They're not supposed to be looking at the IPR considerations of that, because in doing that they might be trying to favour one or other company. So it's supposed to be engineers working purely on the best technical solution. Now, of course, that's all very well, but patents and IPR are there, and a big concern was that ETSI didn't want years of work going into the development of a standard, only to find that a particular company decided not to license its patents and could block then the implementation of the standard. So the ETSI IPR policy was developed, and this requires companies that take part in the standardization to commit to licensing on the Frand terms that we've heard about, both initially by giving general declarations of willingness to license on Frand terms, so that ETSI had comfort that if the standard that was being developed was not going to be blocked, and later to more specific declarations to give implementers more insight into what patents were out there, what companies actually had holdings where they might need to get licenses from. So this foundation has been in place for a long time, and as you say, Gabby, it's worked very well over the years. We see, and there's a lot of focus on the big disputes, but what there's maybe less focus on is the fact that the big disputes are only the tip of the iceberg. The part of the iceberg below the water is all the deals that are done on a Frand basis and in the telecom area, which has been my focus, they have enabled one of the most successful product developments. If you think how far what you can do with a mobile phone has moved in 20 years, it's a very competitive and well-functioning industry. So I think that, yes, that gives the basis, the underlying basis for it.
Thank you very much, Kevin. And I just want to say hello to JJ. Sorry, we started a few minutes earlier. We just skipped the break on demand of this, but thank you for joining us. I know it's utterly early in your area, but we introduced you already. But let me summarize, Kevin, a little bit what you said. I think one of the things I've noted that it's the best technical solution that should go into it. It's not about where I have a patent, and that litigation is like a tip of the iceberg. But let me move to the next panelist, which is Mr. Mittal. You're representing TSDSI, and you are also now for several years working in standard setting, working with setting standards in the respective areas. Can you tell us a little bit about how India, what you're doing, and how this is working, and about your IPR policy, please? You're maybe muted.
You are mute. You
I
are on
unmute
mute,
you.
sir.
Yeah.
Wait. Sending request to unmute.
You have been given the rights to unmute yourself, sir.
You have to. I can't unmute you. I'm sorry for that.
I think I was the person who was unmuted, whereas I think it's
all
Dr.
the
Mitchell's
speakers.
turn to speak.
Mr.
All
Mittal,
the speakers have been given the right, sir.
you can
Nathan, can you unmute?
you can push the button on unmute yourself.
I think he has some technical issues, I guess. You may, yeah.
Let's see. You are not able to unmute him. Okay, let's see.
His WebEx has hung up, so he's joining again.
Okay.
He's joining again. Maybe Gabby, you may want to go to another speaker in that time, if you may wish.
Yeah,
I leave it up to you. I will leave it up.
My flow, but let's see.
Yeah, no, you may wait for him. No issues.
Yeah,
No issues. He would be joining.
But let me, while we are waiting, then just on the fly ask Jay and Eric what you heard from Kevin. Are you agreeing to that this was a working solution and has that it was mutually going for the best technical solutions? Or, I mean, Jay, you have been an inventor. I mentioned this before. Eric, you've worked a long time in this. So, any observations on what you heard from Kevin from your end? Now you are muted, Jay.
I agree with Kevin, and I've definitely found various working groups that are typically formed in an SSO or SDO to very much have a process wherein different solutions are presented and they're evaluated, and there is a lot of checking and contesting that goes on. And this is entirely technically based. This has nothing to do with reward or economics or licensing or any such thing. This is just simply, hey, how can we best accomplish this a way to handle traffic in bad transmission conditions, or some coding modulation issue, or that sort of thing. It's very much on a technical level. And so I do think that the best solutions do rise to the top, and the number of different companies that own various SEPs, and in percentage terms, the fact that very few of them have, more than even 10% of the total SEPs in 4G or 3GPP or 5G, et cetera, is proof that what you have is people working hard at coming up with solutions, and then sometimes you win and sometimes you don't.
Okay. So, Mr. Mittal, we see you now again. So,
Yeah. Sorry, my WebEx program just hanged up at the right moment, at the wrong moment, I guess.
we're anyhow happy that you were on such a short notice prepared to join this panel. So the word is yours. I hope you understood my question. So please.
Yeah, and I understood. So can I start?
Yes, please.
Because another speaker was speaking, so I thought. So. Okay, so thank you, Gabriel, for that introduction, and greetings to all the panelists and the audience here, distinguished audience here. So TSDSI, we started functioning in the year 2014. We were established in 2013, but started functioning in 2014. And how this came about was that a feeling within the government establishment that for successfully contributing to telecommunications standards and having a competitive industry and indigenous development of telecom technologies, there is a need for a standards body. So this was stated in a national telecom policy of the year 2012, that such an organization which is recognized by government will be established. And that is how TSDSI came about. It is in private sector, it's a private body, but initiative is taken by the government and people came together. And we started with about 11 members at that time, and today we are just going to touch 100 members. And the pickup has been faster in last 2 to 3 years. We have exponentially increased our numbers. So, so TSDSI in the initial years, as it everybody can understand that making standards is something where people first must understand how to make standards, where they can intervene, what are the things which can be brought on the national and international platforms for creating standards, and having an ecosystem where people come together and create generate ideas for standardization. So after those initial forming years, what the first thing which we could do, which could bring us to the global scale, was our technology 5GI. Many of you have heard, which was basically, it was based on CGPP, but there were India-specific, basically, they were actually global requirements, but generated from India for rural coverage at lower cost. So we'll not go into details of technology, but just to mention that how much time it took to bring that to the scale that we started somewhere in 2016-17, starting with CGPP and then going to ITU, and finally getting accepted in ITU in the year 2020 as a part of IMT 2020. So during this period, the challenges were to keep the enthusiasm of the contributors of those technologies, that okay, you be there and then let this technology be tried, people understand, and be engaged with the global companies and member states of ITU, and then finally it got an acceptance. So everybody has knows that the perseverance which is required in standards world is something which we tried on first go itself. And now if we take off the development of standards in 3GPP, our number of individual members or IMs for 3GPP, which we used to be around 19 or 20 till about a year back, now we have 55 IMs. And this number is going up because we have a lot of startups in India after the Make in India policy and the startup support to the by the government. The startups have started coming in. They have a lot of innovations, but they really do not know how to take them to the standards. So TSDSI provides a platform for them to come together and also interact with people, and we may provide even some hand holding to them to introduce to them 3GPP working and all that. So we are on that course. that the people are coming together. There is a good mass of ecosystem here which is built up and which will be growing. And probably in coming few years, we will have more standards coming out of TSDSI. One smaller standard which we did was CPRI front hall, which was a greenfield done by TSDSI. It remains a TSDSI standard. But we have a provision in our government policies, the Telecom Engineering Center, which is the technology arm of Department of Telecom. So they have a policy for adoption of standards which are created by TSDSI or similar bodies. So, and as per our rules and regulations and working procedures, whatever standards we develop, whether they are our own greenfield standards or whether they are transposed standards from 3GPP or other organizations like 1M, 2M, we refer them to TEC, and then they consider them to take it to a national standard, adoption as a national standard through a wider public consultation. So that has happened. Number of transposed standards for LTE advanced, and before that IMT 2000 have been declared as national standards, and that thing is going on. Another thing which has happened is our compliance to ITU-T requirements for A.5 qualification. Qualification 8.5 enables standard body to get their standards referred in ITU documents, ITU recommendations and ITU reports. So it was a very tedious process to qualify for 8.5. And one of the important parts of that was compliance to ITUR common IPR policy and copyright policy. So we had an IPR policy which is similar to our organizational partners of 3GPP, but even then, because languages are not same, there are some specific provisions. So there were a lot of very engaging discussions with ITU, and finally we could convince that we are compliant, and 8.5 qualification is almost just, we are maybe 1 millimeter closer to that, maybe declared. So that is how TSDSI's journey has been, and IPR declarations are not very many, because what we did that in the IPR policy, we made a provision that for the companies who make declarations, especially for 3GPP standards or 1M2M standards to their parent SDOs or SSOs, whatever name they are called, those they can declare to us by providing a link, hyperlink that, okay, these are placed there, because redeclaration, there are some issues which were found that re-effort to redeclare, etc. So that has enabled companies to be more forthcoming to declare IPRs to TSDSI. Thank you.
Thank you very much, Mr. Mittal. So I'm going to summarize and also congratulate for a successful part in the standard. And I understood from Mrs. Kumar when we talked to her that more than 70% of people live in rural areas, and the new standard is making sure that there is access for people to it. So I think you contributed successfully with the standard, technically very good solution, helping society and being technically the best solution to it. Okay, if we move a little bit on, the headline of our panel is also introduction into the jurisprudence there. So if all would be all the time good, we wouldn't sit here, there wouldn't be any decisions on things. But I think we would like to give an introduction and some basic outlines, specifically by Eric Stasik and Jay, on the decisions, which are the key decisions over maybe the last few years or years in the SEP and Frand licensing area. And we start with you, Eric. So please, the word is yours. Give us an introduction.
Thank you for that introduction, Gabby, and good afternoon to the audience. I think echoing Kevin's comments that this is SEP licensing has been going on for a long time, and for the most part, it's been pretty well functioning for a number of different reasons. There's been SEP licensing sort of heavily since the 1990s, and it wasn't until 3G or the late 2000s or early 2000s, sorry, when GSM began to take over and we started to enter 3G, that the so-called smartphone wars began. And the real big conflict, I think, that I recall of was the 2007-2008 dispute between Qualcomm and Nokia, which went to the European Commission, which involved other parties, which was really the first big set piece litigation, I think, of the smartphone era. And it happened just as the smartphone was being introduced even though Qualcomm didn't have a smartphone. They were at the end of that. They introduced this sort of big litigation that took up all the issues that we see today, issues about Frand, issues about discriminatory practices, issues about Qualcomm's no license, no chips policy, issues about where in the supply chain licenses should be granted, issues about the royalty base. All the things we're still debating today were really in that 2008 litigation. And there was a complaint that was filed with the European Commission back then, which was withdrawn because the parties settled. And that's a recurring theme. I heard some disappointment in the last panel that the Indian courts have also been denied the opportunity to render decisions that would provide some clarity because the parties have settled. And this has also been the case in the European context. I mean, we had the next big cases I can think of were the European Commission's investigation of Samsung asserting their SEPs against Apple, and then Motorola also asserting SEPs against Apple. In the Motorola decision, the commission came down and said that Apple's seeking of an injunction was an abuse of their dominant position. In the case of Samsung, Samsung agreed not to seek injunctive relief. So again, the commission didn't really get the chance to have 100% clarity on that. And like most of these things, they're really specific to the facts of the case and not general proclamations about Frand. And the first big decision we've had that's sort of the guiding post for everybody now is the Court of Justice for the European Union's decision in Huawei versus ZTE. And that also involved the ability to seek an injunction for the infringement of an SEP. And it involved two Chinese companies. And I've always had in my mind, I don't know for a fact, but I've always had in my mind this was a little bit of a setup that these two companies wanted to create this dispute and wanted to make sure that the dispute made it to the CJEU so that there would be some decision on it. So there was never any settlement between the two companies. But in any event, there was a decision. And this was the sort of the landmark decision in jurisprudence in my space, licensing, SEP licensing, because the court said that yes, it is not a per se violation of the competition law to seek an injunction for infringement of an SEP, provided certain behaviors are followed or conducted on both sides for licensor and licensee. And they put forth this 4 or maybe 5 step process that we call the Frand dance. And it was briefly mentioned in the last session. I'll just briefly mention it again now. It basically says the SEP holder has to alert the alleged infringer. They have to identify the SEPs being infringed and specify how the infringement occurs. The alleged infringer has to come back and express a willingness to take a license on Frand terms and conditions, and then the SEP holder has to present a license offer or an offer specific enough so that the terms and conditions are set forth, in particular the royalty rate and how it is to be calculated. The alleged infringer, having received the offer, should without delay either accept the offer or they should make a counteroffer explaining why their counteroffer is Frand. And this should be again done without delay. And if the SEP holder doesn't accept the counteroffer, or the licensee hasn't accepted the original offer of the SEP holder, then the implementer is required to provide security from the point from which they rejected the offer to avoid injunctive relief. Then there's a 5th step in that it's not talked about a lot, but it says that the parties may agree to have this dispute settled by a third party, either arbitration or through a court. And we've seen that happen in a couple of cases, and I'll mention that in just a second. Okay, so I just explained what this is, the Frand dance. And the Frand dance is pretty well established. I'd say there's nothing new in it. It basically sort of codified the way good faith licensors and licensees interacted with each other up to that point. But it laid it out in a very stepwise fashion. But it's not really clear. You can see there's a lot of room for interpretation there. And so 2 big cases made it to the German Federal Court of Justice, the Bundesgerichtshof, the BGH. And these cases are known as Sisvel versus Haier 1 and Sisvel versus Haier 2. Haier is a Chinese company. It was a very small volume manufacturer of UMTS handsets. And in fact, before both of these cases made it to the BGH, they had withdrawn from the market, so it was kind of a moot point. Again, it looks something like a setup that they wanted these cases to go all the way forward, so the decision would be made, but but we have a decision. And basically, in both of those cases, what the court did, the German court did, was to clarify a few of those steps in Huawei versus ZT. And the first one was that the allegation of infringement doesn't require you to provide a claim chart. All you really need to do is identify the product and the patent number, and that's sufficient in the view of the German courts to notify of infringement. Sorry, that was the finding of the higher regional court in Karlsruhe that provided the basis for that case being referred to the BGH. And the other big thing that they clarified was at step 2. And it said that it doesn't require that a specific written license offer is provided only after the target licensee declares its willingness. One of the things that's remarkable about Huawei ZTE is that you see what appears to be a step-for-step sort of interaction, like tennis. You hit the ball to me, I hit the ball to you. And it looks nice on paper like that, but it doesn't really work like that in practice. A lot of the steps can be omitted. They can be run in parallel. They can be taken out of sequence. It just sort of depends upon the dynamic between the two parties. And basically, the German court recognized that and said, yeah, you don't have to wait until a specific willingness in order to provide your license offer. You can do that straight away if you want to. And it satisfies that requirement. And so these things have been very helpful for me as a licensing person to understand what my behavior should be in a licensing context. And the last two big cases that I'll mention that have had resonance in the licensing space has been, the first one is the Unwired Planet decision in the UK by Judge Burris. This is a case between Unwired Planet, which was a non-practicing entity who had acquired patents from Ericsson, I believe. And they asserted these patents against Huawei. And this was the first situation where a court anywhere made a global Frand rate determination. And this was done without the consent of both parties. Huawei never agreed to it, but the court took it upon themselves to make this global Frand rate determination. And they went ahead and did that. That case was appealed to the UK Supreme Court, which upheld it, I think, on every point. So that's a real touchstone. And the way that the judge in that case, Judge Burris, made a Frand rate determination is interesting. It's very specific to the facts of that case. I don't know if it applies in other Frand disputes, but it's an interesting thing to follow. And the next and final thing I'll mention is the following the court's lead in the UK, the Chinese courts also took it upon themselves to make a global Frand rate determination. And this is a case involving Sharp versus Oppo. And this was a case that was being conducted at the district court in Shenzhen. And it went all the way up to the Supreme People's Court. And the Supreme People's Court decided that it was within the jurisdictional authority of the Shenzhen court and appropriate for them to rule on global licensing terms for SEPs. But the Chinese court made a caveat, and they added 4 factors to why this was appropriate in that case. And the first one was they said most of the patents were Chinese patents. Oppo's main business is in China. The parties had actually conducted licensing discussions in Shenzhen, which was all true. And the licensee's assets, that's Oppo's assets and properties, were also in China. So what the Chinese court did is they said, well, we'd like the idea of a court making a unilateral global Frand rate determination, but we don't want any court doing it. If it's going to involve a Chinese company, it's going to be a Chinese court that's going to make this determination. And that's, I think, why they added these 4 sort of very specific factors that tied that case to the jurisdiction of China. So that's the big thing right now. And these are the cases I've been following and that sort of affect my behavior as an SEP licensor.
Perfect. Thank you very much, Eric. Now let's move to Jay. US important market, and you have basically a lot of knowledge in the area. So can you tell us a little bit maybe about latest decision in the US and some of your experience, please?
Yes. Good afternoon, everyone, and thank you for inviting me, and thank you to the panel members and the moderator for conducting this session. I thought I would talk a little bit about some of the decisions that have been made in the last, say, 12 to 13 years in this area. And, one of the very first decisions in the United States was in the Microsoft versus Motorola Mobility case in the Western District of Washington, which was then affirmed by the Ninth Circuit in 2012. And really, there's been a fair comment would be that there's been a global sort of consensus around how these SEP disputes should be viewed. And in the sense that the Frand obligation was developed to try to avoid this hold up situation where an SEP holder refuses to license their patents to a licensee or an implementer. And so the Frand obligation was sort of designed to do that. But having said that, the courts have begun to recognize, and this has been true in the United States as well, that this does not preclude the possibility of trying to obtain an injunction in situations where certain conditions are met that Eric talked about. And so in those situations, an injunction may be justified, even though the Frand obligation itself doesn't contemplate something like that, because after all, the Frand obligation says, let's work together and figure out what the reasonable royalty rate is. And nevertheless, it was made clear that an injunction would be available in situations where you have an unwilling licensee. Having said that, Microsoft versus Motorola Mobility was a case where the court, Judge Robart, went to great lengths to try to apply the so-called Georgia-Pacific factors in the United States. We have this old case from the 1970s where you look at a variety of factors, 15 factors, to try and determine what is the reasonable royalty. And a lot of it comes down to what has been the past record in terms of what other licensees have paid for the same portfolio and who happen to be in similar circumstances to the defendant or licensee. That sort of track record, so that you're basically licensing the portfolio on same or similar terms, and that sort of makes it fair and reasonable. And so Judge Robart actually went through and found certain percentage in that particular dispute, sort of modifying the Georgia-Pacific factors to determine reasonable royalty to the situation involving an SEP holder and an implementer. And in that particular case, ultimately, it was about $14.5 million was won in damages by Microsoft. And in addition, the issues on the other side, on the licensee and implementer sides, was also brought up. And so you see situations where validity of the standard essential patents can be disputed, where essentiality of that particular SEP for that particular product can be disputed. And in some cases, there have been disputes about whether this is a quote unquote core or a compulsory SEP, or an SEP that's really an compulsory for an option in the product. In other words, if you have a product where that option is offered, then this SEP is required. Otherwise, it's not required. And so these sorts of issues have come up in the United States. And there has been a lot of criticism as well. In all fairness, I have to say that there's been a lot of criticism of decisions in the United States as perhaps not being as friendly in terms of the royalty rates that were set by these decisions. In other words, these royalty rates have been quote unquote low, and that creates a disincentive for patent holders to get into this SEP Frand scheme to begin with. In other words, this Frand royalty rate might actually be lower than what might be a reasonable royalty rate if the same patents were not SEPs. And so there's a lot of criticism on that front as well. I want to just take a minute or two to talk briefly about what I see as, from an external perspective, and in sort of linking up to the next panel, the decisions that I see that have been coming out of the High Court in Delhi have actually been very much in sync with some of these same cases that we just talked about, whether it's Microsoft versus Motorola Mobility, or Huawei versus ZTE in Germany, or Unwired Planet versus Huawei in the UK, Sharp versus Oppo, and so on. What I wanted to say is that it seems to me that at least the courts, and particularly the High Court in Delhi, seems to recognize the issues and the tensions on both sides, and understands the issues related to ownership of the SEP, the validity of the SEP, the essentiality of the SEP, infringement of the SEP, and so on. One of the things that I would say has been little unusual to see, as someone who's sort of used to doing patent litigation in the United States, has been this interesting posture that you see in India, where the SEP holder typically moves for a preliminary injunction, and then the courts engage in a very extensive discussion of all the merits, and it's very much like what you see in a trademark dispute, typically in the United States. And then the preliminary injunction is the subject of a detailed opinion, and the preliminary injunctions may or may not be granted. But then, very often, right after that, the case is settled. And so, what you have for the most part is only the entire action of the litigation shifts to the preliminary injunction stage. And that's sort of what we saw in the cases that Ericsson has brought against Micromax and Intex and Lava and so on. And then the same thing was sort of very similar things in cases brought by Ringo and Dolby and so on it would be sort of, in fairness, I should mention that there has been one full post-trial judgment involving Philips versus Mangalam Technology and Bhagirathi Electronics, where you actually had a full post-trial judgment, and even in those cases, I think that there's actually been a good discussion of the issues and a good fair airing of a lot of the things that we talked about. And I also noticed that the reasonable royalties, to the extent that the courts have awarded them, and so the extent that they are known, have in fact been very reasonable and quite low, you might arguably say. For example, in the Philips case, it was the royalty rates were between $1.90 and $3, as I recall, per DVD player, as I recall, and roughly about 5 lakh Indian rupees, as I recall, in damages. And so again, very modest sum. But I do want to mention that in closing, that the courts actually seem to be across the world sort of understanding the disputes very well and have been examining the evidence that presented by both parties and the expert submissions and come up with well-reasoned opinions to deal with this area. Even though it's just been about 10, 15 years, I think there is some good jurisprudence that is emerging. And I'll stop right here.
Perfect. Thank you very much, Jay. Very good summary. Time's flying when you have fun, and obviously if you want to allow a little bit for some questions from the audience, and at the end I just have to finish with one question to all of you, and I start with Kevin. But let me also just a short summary. You said implementers, the people supporting the standard, they need a fair return on invest. Their royalty rates might be set lower as if they wouldn't be standard essential patents, which would be detrimental for the standard setting companies on it. My question now goes to all of you, because also for the panel we heard before, and Jay, you might not have heard it, that there was a shout out for policymakers to influence. Can I ask you, and sorry, it's an unprepared question for all of you, but I have to ask it now, is do you really think that policymakers should involve themselves in setting rates, in setting these ways? Should there be rate setting by courts at all? Shouldn't it be between the parties that know best what should go? So question, Kevin, do you think that there is a need for policymakers really to involve themselves in this SEP?
I think there's a lot of noise here, but I think for there to be a need for policymakers to involve themselves, you would need some evidence of a problem. And as we've said, most of the time this gets fairly well sorted out by negotiation between companies. And when it doesn't get sorted out, for all the talk about hold up, it's something that's not really possible, because the theory of hold up is that you can get high rates through an injunction. But I think, as Eric and Jay have mentioned, the courts are getting quite well coordinated in the setting of royalty rates and being able to look at comparable agreements and all the factors around that. So there's enough out there. The courts have all the tools they need. They seem able to do it. Most of the time it works. And as I mentioned, this has been a really dynamic market. Not only, I guess I'd mentioned in terms of features in phones and the technical features you have, but also if you look at how it's changed in terms of companies. So maybe it's been a little bit more stable the last few years, but this has also been one of the most dynamic industries in terms of companies coming in and going out of it, which again is not evidence of something where there's the kind of problem that needs regulatory attention, because it seems possible for people to come in and start up. Old people, the older companies, if they aren't successful, they fall away. So I think that's a long-winded way of saying I'm not sure there's so much evidence for that being necessary.
Thank you, Kevin. Eric, maybe I'll continue with you. I'm sure you have advised implementers as well as all parties. So what's your view?
Yeah, I tend to agree with Kevin that overall it's a well-functioning system. But I, having worked on both sides of the table, there's challenges. Things could be made easier. But that being said, I don't know if there's a better solution than the one we have. I know that George Contreras at the University of Utah has written really and argued compellingly for some kind of global tribunal, Frand rate-setting tribunal on the lines of a copyright tribunal. And it's really compelling, his arguments for it, but I don't think it works better than the system that we have. So I think that these are just contentious, difficult issues. And what Frand has done is Frand has moved those contentious, difficult licensing issues out of standardization and put them into the hands of the market to be settled after standards are set. And that's the reason we get a new G every 10 years and a big upgrade like every 17 months. It's astonishing the rate of technological improvement that we see. I mean, I have now faster download with 5G than I have on my cable modem in my office, and I'm going to get rid of my cable modem now because 5G is faster. And it just astonishes me the rate of improvement in the technology. And this is the result, I think, of Frand pushing those issues out of standardization and into the commercial environment. And there's going to be issues to resolve there. These are difficult issues to work out, and there's going to be litigation. And I think that the system works as well as it could work. And I don't see that there's an improvement by having creating some kind of global forum on like a copyright tribunal for these issues. I think they're just too fact specific. There's too many different commercials scenarios where that wouldn't work. And I just hope that people work together and recognize that this is a really successful system. It frustrates me sometimes that some of the big implementers, particularly some of the new ones that have entered the market, are so reluctant to pay for it. This ecosystem, not only of developing new standards, but that already exists, that people can walk in. The automobile manufacturers, it's created an entirely new revenue stream for them. I mean, now everybody pays a subscription fee now to get their real-time traffic information, these other things that the automakers sell. They never had that before. The automakers didn't invest a eurocent into the development of cellular technology, and now they're benefiting from it massively. They should be willing to pay to support that ecosystem, which makes everybody, it's a win-win situation. So that's why I see it.
Yeah. Jay, maybe I go on with you and then I come back to you, Mr. Mittal.
Yeah, so just very briefly, from a purely institutional perspective, policymakers would necessarily, through regulations or otherwise, have to come up with what is some sort of, rough estimate for what might be the Frand rate across a whole bunch of situations. And that's the best they can do because, policymakers don't hold hearings and listen to expert submissions and look at the details in every case. And that's exactly what courts are designed to do. And to look at the uniqueness of that particular dispute between those particular SEPs, that particular SEP holder, and that particular licensee, and then come up with what is a fair, reasonable, and non-discriminatory royalty rate. And so it's really a question of institutional competence. That's what courts are designed to do. They are very competent at resolving disputes and looking at the particulars of a particular situation. It seems to me that it makes sense for policymakers to talk about the kind of factors or the kind of issues that they might want a court to look at, and sort of lay out a kind of a framework in sort of a legislative sort of fashion where you have some rules and regulations, but to actually go and say, hey, the correct Frand rate is 0.5% or 1.5% across a whole range of disputes and a whole range of technologies, and not to mention smartphones, automobiles, all the Internet of Things, all sorts of different applications where 5G technologies are coming to the fore. It just doesn't make a whole lot of sense, and in fact, there is really very little evidence that the courts are not doing a good job. In fact, I would urge that the overwhelming evidence is that the courts are actually doing a very fair job, and as we would say in America, calling the balls and the strikes pretty well, and so I'll make it a consensus with Eric and Kevin that I think the systems is working pretty well with the courts resolving these disputes.
Oh, I see. I want to give the final word also to you, Mr. Mittal, and I think this question would not be a fair question to you, but I'd just like you to ask, and we had a very short chat before, is there, from your view on the TSDSI, any challenge you see and which you just put up here and we might take up in another panel half a year and in some time from now? So what are you seeing as the biggest challenge?
Yeah, so as far as we have seen during the journey of development of standards and taking the IPR related matters or the standards having IPRs to global bodies, of course, the dynamics in the standard bodies is quite different at how a solution is actually accepted into a standard. There may be competing solutions and there may be interest groups who support one kind of solution compared to the other one for various reasons. So that is a challenge we have faced till now, and probably the dynamics of standard development will continue to be like that in future. But while agreeing to the panelists here who said that the current system is working well, where the courts are very competent to decide upon these matters. But one thing which could be considered, and this may be my personal view, because I don't represent government and PSA as a body probably has not made its view on this. As a personal comment, that probably in the economies who are developing, where there is an imbalance between the patent holders and the patent users, probably the governments can have certain kind of guidelines with the industry consultation so that they act as guide to both parties. Ultimately, the solution will come from the courts, but probably both sides will have certain points to ponder that something has come from government. They follow that. If they do not agree, then the courts are there. Because I'm saying so because in the economies where the producers and the implementers, or the SEP holders and the implementers, they balance out each other, then probably there's more equal or equitable negotiation across the table compared to a position where somebody has a dominant position, another person is at the mercy, quote unquote. So to avoid that kind of situation which may exist in the developing economies, probably that could be one solution. But I agree with the panelists that current arrangement has worked well and it is evolving. It is continuously evolving. Thank you.
Thank you. Maybe as a moderator, I allow myself a very short comment to this. I see your point, but I think one of my panelists here said before there's new revenue streams in automotive. When first-time discussions in telecom and automotive came, it was the same feeling of an imbalance, not in the country, but in the technology, and it works. So I don't think that just because a country is developing standards from scratch and from new, that there is a need for working on it. The system will develop itself in a manner. And I think we've seen it very successfully now in the automotive space, I see at least. But I don't want to take too much space here and allow maybe for one or two questions from the rest of it.
Okay, so we have this question for the panelists here. Is arbitration a preferred mode for resolving disputes arising from Frand licensing? If not, which is the most preferred dispute resolution method?
So it's all of you. Who wants to start?
I'll start by saying that nobody arbitrates. There's lots of good reasons to arbitrate. I think that there's been very sensible proposals put forth for arbitration, but in the SEP space, there's almost no arbitration. And that's the way it's been for 30 years. I think that's because the parties would like to continue to negotiate up until the very end. I think that they don't like to put their decision-making into the hands of an independent body. So even in a court is a more likely place to have a Frand determination because at least that can be appealed. But even in that situation, you see that the courts in Unwired Planet and Huawei, there was no agreement between the parties to have a Frand determination. And in the case between Optus and Apple that's now going to the UK, Apple reluctantly accepted that the court would make a Frand determination, but still giving themselves some options out. So I don't know what the best way to go is. I just observe that nobody arbitrates. I think as a result that what you're going to see is more and more of these sort of first instance Frand determinations, and then probably a settlement on the side between the companies. That's probably the best way to go.
I think I'd somewhat echo that. I mean, in principle, arbitration is well matched because it's something that's able to look at a global problem and provide a global solution. It's one of the strengths of arbitration is that it's done in secrecy and you don't get to see the decisions. But that's also one of the big problems of it here because everything in the Frand jurisprudence has been one step building on another. And one court looks to the decisions of another court, sees what it likes, what it doesn't like, what it can improve on, and that leads to something that's evolved in a good way going forward. And it's, as someone who might consider arbitration, first off, it's difficult to get people to agree on what terms they would
Right.
arbitrate on. And because of the non-transparency, you don't know where to go to or what you're letting yourself in for, to some extent. So it's also a bit of chicken and egg.
Jay, anything from you to add? You're muted.
In principle, arbitration, mediation, all these alternate dispute resolution mechanisms, that we have in the U.S., early neutral evaluation, mentioned mediation. I know the question was directed specifically towards arbitration, but all of these in principle are employed in patent disputes. But having said that, it doesn't strike me that these mechanisms are particularly better than the parties directly negotiating with each other, because these are very sophisticated parties in most situations, and they know the specific details and the markets that they face and that they have in front of them, and so they understand each other quite well. And these are also repeat players very often. And these are people who keep going round and round and round. I just noticed that, just a little while ago, we had, some lawsuits in India, for example, in Nokia versus Oppo, where you had, looks like a second generation dispute, where the first generation licenses were actually ending. And so it started a new wave, if you will. So I think in principle it might work, but it's not clear that it might work in this particular situation involving SEPs. Having said that, I think it's still, the verdict on this issue is very much out there, because it's only recently that we've started, as with Justice Burris in the UK, etc., and then the 2020 Supreme Court decision in the UK affirming the global Frand rate. I think it's still very much remains to be seen if a court in a particular country is good and there is setting a global Frand rate. In other words, can one court in one country really take all the intricacies into account and set a rate for the whole world? And is that better done in some sort of international global tribunal, as opposed to a national court in any one country? It sets up a situation where maybe there will be competition between national courts as to who does it better. So I think it sort of remains to be seen, and perhaps there is a role in the future, but I think it remains to be seen.
Okay. I'm not sure. I think we're a little bit over time.
No, I just have one quick question. If you could throw some light on the amount of efforts that go into the standardization work.
Eric, Kevin, Jay? And
it's at least from the inventors I've worked with, it's clearly enormous and grown. I mean, when I was first dealing with this around 2000, the standardization meetings were half a dozen times a year around the world, involving hundreds of engineers and a huge amount of R&D effort behind them, and they've only got bigger and bigger as this has become a bigger industry. And I think they've now moved to thousands of people, somewhat inevitably online, but a very big effort.
I would just want to add, having as an engineer participating in these things, I can tell you that there is a huge amount of effort that is spent, and the problems are very carefully identified and the parties go and work on them, and then they take time to present the papers prior to the meetings, so that everybody has a chance to look at the alternatives that are offered, and everybody has a chance to understand the advantages and disadvantages. And these are companies that spend billions of dollars on R&D, and then very much rely on the working groups within the SSOs and SDOs to identify the key solutions where there is a consensus that develops that this is the best way to go. And believe it or not, even then, you have situations where working groups will change their mind, where they think they want to go a certain direction, and it still might change. And of course, we all remember situations where you even have entire standards developed that still don't get traction in the marketplace. We all remember WiMAX and so on. And so it's very much the case that there's a lot of effort and a lot of technical decisions and a lot of technical discussions.
And allow me to add. Sorry, go ahead.
I'm sorry, Gabby. Go ahead.
No, you go.
Okay, I just wanted to say that it's also a huge and ongoing effort. I made a comment. We've had a new generation every 10 years, and a significant upgrade about every 18 months since over 30 years. So it's not just a focused effort. It's a concerted effort over a long period of time. I had a really interesting discussion with somebody yesterday. He asked me about R&D and return on investment. And if you look at the companies that do the heavy lifting, there's about 4, 5, 6 companies that do all the heavy lifting. And each of them spend 15 to 20% of their turnover on R&D every year, year after year. And it's easily over $100 billion a year, every year, year after year, all these companies together. The global market for SEP licensing is about $15 billion. So if you look at SEP licensing as sort of from a return on investment measure, it provides a pretty lousy return on investment right now. So just the point being that the investments made in standardization are massive, and they're ongoing, and you don't see them all the time. You see them when a new 5G, new 6G comes out, something like this, but it's always ongoing. And like I said, in between, we've had release 15 was the first version of 5G. Release 16 is out. Release 17 is finished, and they're already working on release 18. So I mean, it's impressive, and it's a lot of work.
It was perfect that I let you go first, because being one of the ones, we'll come to you in a second, with the heavy lifting, as you say. And I think we are now thinking about what 6G is gonna be, and that's investment today, and the return on invest by licensing, by setting up the 5G, which is now 4G, 5G monetized, is allowing us to set the new standard, which will come in 5 years, and which will have a product, as you say, in around 10 years. Without this return on invest, the whole system would die and it wouldn't work properly. But Mr. Kumar, you lifted your hand, and I hope I can get a final comment, and then we will close it. As you say, if you have fun, time flies. Not Mr. Kumar, so please. Vital. You raised your hand, or didn't you want to?
Me?
Yeah.
Right.
Yeah.
Okay. So, I agree fully with the fellow panelists that the kind of time and money and effort is required. So I was just giving an example, like Mr. J said, the example of WiMAX, which, became a standard and did not survive, before the 3GPP technology. So at the smaller scale also, when companies start contributing, their engineers work overnight, create proposals, and go to a number of meetings, invest money in travel and stay and all that. But ultimately, many times it happens that the proposal is not accepted. You spend months and months to go to the meeting and it's not accepted. So the crux is that the standards has to be made a business. Unless it is an essential requirement of your business, or you make the standardization itself as a business need, it is very difficult to survive or to persist with the standards. It's a huge effort in terms of money, manpower, time, everything. And a lot of perseverance is required.
And that goes for the big and the small and everywhere in the world. So thank you very much, dear panelists, for joining me. I think I had a wonderful time. I hope that our audience enjoyed your comments. I mean, as said, you have this super large amount of experience here, and I thank you for joining me here today. Back to
Thank
you.
you, Gabby, and thank you, Eric, Dr. Kevin, Dr. J. Kason, Dr. Mittal. Thank you for being with us and giving us your valuable time. It was a wonderful session, and I'm sure the questions have been satisfactorily answered. Thank you all. Thank you all for being with us.